Greg Jemison, you're the principal of Jemison Fisher, a firm specialising in all aspects of agency practice and law. Can you tell us what the hot issues are for agents right now?
Yeah, Peter. At the moment, probably the main three things I've been looking at from our firm's point of view have been show cause notices with the Office of Fair Trading. A lot of breaches in the use of confidential information when staff leave real estate agents, and also the perennial favourite, commissions and agency agreements, always a hot topic.
Okay, Greg, let's go through each of those issues one at a time. Can you start by explaining what a show cause notice is and how an agent should best respond to receiving a show cause notice?
Okay, with a show cause notice, it's a document that's issued by the Office of Fair Trading. It's sent out by the investigators or the manager from the Real Estate Investigations branch. Usually responds from an investigation that's been commenced by the Office of Fair Trading. Probably I'd say the most recent types of examples we've had has been for substantiation of pricing. If there's been an instance of trust defalcations, mainly through the failure to lodge bonds, those always will come up. And obtaining beneficial interest, where somebody in the firm has purchased a property without advising the vendor that they may well have been the purchaser, the agent themselves or somebody close to them.
Right, okay. Now, what about the best ways for an agent to respond to that? Let's say somebody watching this video has received a show cause notice. What are some of the things that they should do?
The process normally starts that the first documentation is not the show cause notice. What they normally receive initially is a visit from the Office of Fair Trading. The investigators come to the agent's office. They'll do a routine inspection, look at all the trust records, look at some of the files. They'll then indicate that there may be a specific complaint they're looking at. They may then talk to the licensee in charge or the particular salesperson. They will try and invite them for an interview on a voluntary basis. My recommendation, obviously from a legal point of view, is that that's not a good idea by a real estate agent. Agents by nature like to please people, they talk to clients, they like to tell them what they want to hear. Unfortunately, for a real estate agent, investigators are trained to obtain information from an agent, and they will continue to ask a question, and agents by nature then will give an answer that they believe will please the investigator or maybe appease the whole situation, which in actual fact may put them into deeper hot water than they already are. They may well incriminate themselves accidentally when they've not actually done anything wrong. What I would suggest is that all of the documentation that's held in an agent's office has to be provided to Office of Fair Trading. What I suggest is that they cooperate, they assist them by showing them where all the records are, answer their initial questions, but when they talk about formally interviewing, that's when they need to be getting some legal advice. When an agent is asked to attend for an interview voluntarily, they have the right to decline. The Office of Fair Trading then will quite often issue them with a compulsory notice which requires them to attend an interview. I suggest that they wait for that notice, because what it does, it sets out the parameters of which the interview will be held. It also means they can take that to their solicitor, discuss it, so they're not ambushed when they get to the interview.
Right. Now, what sort of things should they expect once they do go to the interview with some parameters?
Okay. From my experience, look, it will all depend on what investigator is looking after their particular complaint. Interviews can run from anything from 30 minutes to several days. And I defy anybody who can sit through one of these interviews for several days with tape recorders going. It's a very harrowing experience. It's tantamount to being interrogated. So I do suggest that they do take a lawyer with them, on the basis that at any time a question comes up which they're not sure of an answer, the interview can be stopped. You can have consultation with your solicitor, who will then either advise you not to answer the question on the grounds it will incriminate you, or assist you to understand the question so that you can give an answer that's more informed, which won't incriminate you in any way.
Right, okay. Now, Greg, once an agent's attended a compulsory meeting, if they are then issued with a show cause notice, what should they expect to occur?
Okay, what will happen there is Office of Fair Trading will send them out information of all the evidence that they've gathered, together with their conclusions, and from that, again, I suggest you would need to get legal advice, because what they then allow you to do is either object to their findings. You can either go back to provide oral evidence to them, but you've already done that in the compulsory interview. But what you would do is you would provide them with a written submission as to why you don't agree with their findings. And what it is really a defence. You're preparing a defence from the word go as to why they shouldn't either disqualify you from holding your licence, issuing you with a fine, or taking some other disciplinary action. In the worst case scenario, Officer Fair Trading can make the decision as to any penalty in-house on the evidence obtained by their investigators. Then your right of appeal is to the Administrative Decisions Tribunal, where then all the evidence is put before a tribunal member. You have the ability to cross-examine people there, just like in a normal court situation. And so far, most of the cases down there have been reasonably favourable to agents.
Okay, let's look at the issue of confidential information now. Can you explain firstly what confidential information is, and then perhaps give us an understanding about what the impact would be on agency principals, salespeople, and also property managers?
Okay. With the confidential information, it's obviously very important in a real estate business because you're building up goodwill. Rent roll, the list on your rent roll obviously has an inherent value. There's potential listings, market appraisals, which can be converted obviously to sales. There's also confidential information such as advertising contracts, franchise agreements, staff structuring, those types of things, and databases. What salespeople and employees need to be fully aware of is that information belongs to the business and not to them. A property manager or a salesperson who brings in a client into the business needs to be aware that even though they've converted that person through their own hard work and their skill, that client is inherently belonging to the business because the business has provided the name, the telephone, and the ability for that salesperson to convert that person to a potential client of the business. So when a salesperson leaves and goes and works for another agency or opens up their business, they can't take the database with them. They can't take their diary with them and contact every previous market appraisal. Same with a property manager. They can't contact every past landlord and say, I'll do a better deal for you down the road. What the consequences of this are is that the employer can apply to the Supreme Court to get an injunction for restricting the salesperson or property manager from contacting any person from that database for a period of 6 to 12 months. Now in the meantime, if that salesperson continues to contact people, they're in contempt of the court. So obviously contempt of Supreme Court carries a jail sentence with it. But more importantly, and where this affects all parties, is it is very costly to go to the Supreme Court, and anybody embarking on a new career can't afford a $30,000, $40,000, $50,000 legal bill for being stuck down in the Supreme Court. Not only that, they're not out earning commissions while they're fighting court cases. So all round, people need to be very aware not to take confidential information when they go off to a new agency.
Okay, now what about agency agreements? What are the current issues for agents?
Yeah, I mean, there's always the age-old issue of compliance with agency agreements with the new legislation, which is not so new anymore. Again, agency agreements are very prescriptive. Agents have to be fully aware and continue to be vigilant in filling out their agency agreements, making sure they don't leave anything blank. And again, I suggest they use commercially prepared agreements and not decide to prepare their own, because they'll always leave out some minor issue. But one of the things that I'm finding at the moment is, because of this change in the market where it's more a buyer's market at the moment, and we're finding that properties are staying on the market for a lot longer than they did in the past, it's very common now for a vendor to sign up with one agent, not sell their property, and then move on to agent number 2 to sell their property. Given that buyers are also a little bit more savvy at the moment and making numerous offers trying to get a bargain, you will quite often find a purchaser will come along, see a property through agent number 1, make a ridiculous offer, go away, come back in 4 months, 5 months time when it's with agent number 2, make the same offer which is now accepted. We now have a situation is that the purchaser was quite obviously introduced by agent number 1, But the question now is, was agent number one the effective cause of introducing them? That's always a difficult question, and that will always turn on its own facts. But again, agents need to be fully aware that what they have to do is keep good file notes, good diary notes. So of every inspection they conduct with an individual purchaser, they need to diarise it, make notes as to how long roughly the inspection was, how many inspections they had, particularly if somebody asks for information. So if contracts are passed on to that person, they need to make a note that they've obtained a contract, that they've organised a pest and building report, they've attended at the particular premises to let a pest inspector in, they've made arrangements with the council to get some sort of documentation or some records for them. So they need to be able to show every step they've taken in that introduction of that person, which may be of assistance if they need to fight for their commission later on down the track.
So Greg, if an agent had received 3 or 4 offers and then counter offers and passed them on to vendors, making file notes about all of those telephone conversations would probably help you once the client comes to see somebody like you?
Certainly when we get into the court, we find that the judges and particularly a lot of these matters end up in the tribunal. A lot of the tribunal members find if there is substantial records within the file showing telephone contact, inspections, it creates a situation where the tribunal can make an easier finding that the person who first introduced was not only the introducer but also an effective introducer. And we're getting a situation more and more in the tribunal where we're having 2 commissions awarded against vendors for the first agent being the effective cause and the second agent having the exclusive agency. So again, good file notes. I know it's not an agent's trait, but that's something they've just got to get into a habit of because they don't want to lose these commissions.
Greg Jemison, thanks very much for your time.